And you're listening to the Diane Rehm Show. I want to read for you a portion of an email from Jay, who lives in Massachusetts. He says, I was ordered by the court to pay my ex-spouse 180% of my unemployment benefits while I am unemployed. I'm at the end of my career, having a very difficult time finding a job after my position was eliminated. My ex does not have to touch the 50% of assets received in the divorce settlement. It's just plain crazy that the amount of alimony paid is set when you are working at the peak of your career and you get no relief when you're having difficulty. And Anson, I gather you'd agree with that.
Well, the one thing I certainly did learn sitting on the bench is that there are always two sides.
Of course.
And this sounds just awful. It's one of the reasons why I always look for an alternative to alimony. I'm trying so hard to help these people do what they say they want to do, which is to untie themselves. And I think alimony keeps them bound on a roller coaster, whether it's good fortune or bad. Usually somebody doesn't share in the good fortune of the payor, but they certainly do share in the misery. So the difficulty, of course, is if there are not other assets to be divided, then what?
And joining us now by phone from Melbourne, Florida, is Alan Fisher. He's president of Florida Alimony Reform. Good morning to you, Alan. Thanks for joining us.
My pleasure. Thank you for having me.
Describe the alimony reform that you pushed for.
Well, what we tried to do, and because I'm basically down in the trenches, I was listening to what everybody was saying, and certainly academically and legally there are words written on paper, but what is practically happening in the courts are a whole other thing entirely. The arbitrary and unbridled discretion of many judges, in this case, ruling on these cases, give them the ability not to be consistent, not to have any predictability. And like the judge said, 5 different judges can have 5 different opinions. More importantly, the same judge can have different opinions when basically the same factual situation occurs in cases. So what we tried to do with the reform movement in Florida is allow for certain guidelines to be put in place to allow for predictability and consistency throughout the state.
But I gather that your goal is to eliminate most alimony.
No, well, that's not the case. We actually believe that a certain amount of rehabilitative alimony is quite necessary in most cases. What we've tried to do is eliminate the permanency of it. We don't believe anything should be permanent in the law. And while modifications can occur, we found practically that's very rare. Most judges do not allow for modifications when they do go before the judge to ask for them, because there's no definition of what a significant change of circumstance would be.
So Governor Scott did just veto that permanent alimony bill. I gather he had concerns about applying the law retroactively.
Yes, he did. I was recently at a dinner with Governor Scott, and I had the opportunity to speak with him personally about this. And he said while he is for reform, he believes that the retroactive part of it would have been very challenging and very difficult. So he wants me to come back and present something different to him that may be able to allow for a certain amount of retroactivity.
All right. Alan Fisher, President of Florida Alimony Reform. Thanks so much for joining us. And short break here. We'll be right back.